Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Welcome to another episode of Empowering Plans. Today you have myself, Kelly Dempsey, along with Jen McCormick in the consulting department to talk about super fun topic of the Pregnant Workers Fairness Act, which is otherwise called the PWFA. There's been a lot of buzz recently about this, or maybe you've overlooked it because there's been a lot of buzz of everything's happening in the industry, but we want to kind of take you back in time, go through the background of where we are, where we've been, what the statute really is, and then talk about a couple of current court challenges, and then what are plans supposed to do? What are self-funded health plans supposed to do? Because there's so much happening in this space right now. So way back in December of 2022, Congress passed the Pregnant Workers Fairness Act. As in true Congress fashion, they passed it literally on December 27th, 2022, right in the middle of the holidays when nobody was paying attention. And subsequently, it went into effect in June 27th of 2023. So what that means is that as of June 27th, 2023, the EEOC would have started accepting challenges for violations of this act at that time. So if somebody had a complaint, they could file a complaint against their employer all the way back to June of last year. In April 14th of 2024, the EEOC issued its final rules. So this includes interpretive guidance relating to the importance and all the details, the fact sheets, all that stuff related to the Pregnant Workers Fairness Act. So the regulation officially went into effect this past week, actually on June 18th, it actually officially went into effect. So here we are. You might recall we did some webinars where we talked about this last year after it was passed, as well as when it went into effect. We did talk about it, but if you can't remember, here we are today to kind of go over what happened. So who does this apply to? This regulation applies to employers that have 15 or more employees, and it requires them to provide reasonable accommodations for employees with pregnancy-related needs. That's kind of the plain English version. So this applies to private employers as well as public sector employers for state and local governments that have 15 or more employees. It does also apply to Congress and other federal agencies and employment agencies and labor organizations. So pretty broad reaching application, applies to obviously very relatively small employers with 15 or more employees. So pretty broad reaching scope. So I will turn it over to Jen to talk a little bit more about what this regulation actually is, what it does, and what it means for employers.
Thank you, Kelly. Yeah, this is an important regulation act that has been put into place. And we'll talk about at a broad level, really what this act is doing for employers, setting us up to really understand the nuances, the overlap, the integration, and now the things that we need to be aware of as this is actually in effect and live. It's going to require us to be aware of some different pieces and to really think through, and hopefully we can have some examples that we share together today, Kelly, that are helping people to really understand the impact that this statute's going to have. So what is it doing? What is the Pregnant Workers Fairness Act going to do for employers? So it requires that if there's a covered employer, so one of the type that Kelly had mentioned, as long as the employer is part of the eligible employers subject to this act, that they would now be required to provide this reasonable accommodation to a qualified employee or applicant to their known limitations, and these could be related to or affected by or arising out of the pregnancy, the childbirth, or any sort of related medical conditions, unless this accommodation would cause the employer any sort of undue hardship. So there's a lots of different terms that I used in what this act actually does, and let's start to unpack this so we can really understand all of those pieces. What is reasonable accommodation? What does now this mean that we have to not only include a qualified employee, but an applicant? What are these known limitations that are related to the pregnancy, childbirth, or medical conditions? And what does it mean undue hardship? And we have to keep the Pregnant Workers Fairness Act rules and these nuances that have been provided to us in line with what we already know about some of these laws and statutes that are currently in effect, and how are they going to work together. So when we're talking about the undue hardship component, which I think that is important for us to understand here, this is a lesser standard than what we have really thought through and really understood in the past of what that must mean. So this is not supposed to be something that is simple. What are the types of things or situations where there wouldn't be undue hardship for an employer? If we could think through some of these examples, then I think it's important for us to understand what it means. So essentially, under the ADA, which is a different act here, the Americans with Disabilities Act, there are different standards that are coming into place for us to understand whether somebody could or couldn't do their job. Ceasing their job and all of their essential functions is a pretty high standard. And under the ADA, when we're talking about an undue hardship, that is a separate standard than what we're talking about with the Pregnant Workers Fairness Act. So here, we just need to make sure that the standard here that the employer needs to provide is separate, and we're following not only what the ADA analysis would be, but what the Pregnant Workers Fairness Act is going to be. And each of these different analyses were going to have to be different based on the facts and the circumstances of the individual employer, of the individual's circumstances. But the key point to highlight here is that this is not something that employer has to offer, this reasonable accommodation, if it's going to cause an undue hardship, but you have to separately understand what the ADA standard is and what the Pregnant Workers Fairness standard is going to be and how they're going to interact together. So it's giving us another nuance to consider when we're trying to unpack whether or not this is something that we should be allowing for. The second piece to consider here from what this act is requiring us to do is taking a look at something that's relating to or arising from a pregnancy, a childbirth, or a related medical condition. And this is where we're going to talk about some court cases in just a couple of minutes here, some challenges and things that we're starting to see. But when Kelly, you had mentioned back in April, just a few months ago, that the EEOC had offered us interpretive guidance, which we welcomed, some additional details and nuances to really understand the impact of what this statute is going to mean. How are we supposed to be applying this? So some of the examples that the EEOC gave us that would fall within the category for which the Pregnant Workers Fairness Act would apply, and we know that this is applying for employers who have 15 or more employees, so this is a broader pool of people than other statutes that had been required or mandated to comply with pregnancy-related issues. But we're talking about infertility or fertility treatments, pregnancy-related sicknesses, maybe this is preeclampsia, maybe this is vomiting, maybe other conditions that are related to pregnancy. Lactation is a potential consideration, menstruation, the termination of pregnancy, including things like abortion. So this is a broader scope of situations that could fall within scope of when a qualified employee could be eligible to request and then the employer to provide the reasonable accommodation. So why do we need this? This is something that is going to be important for employers because it is essentially a gap filler. It is filling in the blanks where some of these laws maybe only were applicable for a certain type of employer. And a really good example of that is the FMLA. There is some interaction here when we're talking about the FMLA. We've had the FMLA for a number of years, and we're all familiar, hopefully, with the FMLA and its protections that are allowing eligible employees to take a leave of absence if they otherwise meet the qualifications. This is offering unpaid leave for up to 12 weeks based on the situation following the birth of a child, but this is only applying to applicable employers that have 50 or more employees. So that is a higher threshold than we have here with the Pregnant Workers Fairness Act. So the other things that we need to keep in mind here too are the Pregnancy Discrimination Act. And while that is a separate act, we have to be mindful of the fact that together with the Pregnant Workers Fairness Act, we cannot discriminate or fire or treat illegally any of these individuals because of their pregnancy, because they need to take maybe extra bathroom breaks, or maybe because they have to have a standing or a sitting break, or maybe they need to work from home, or maybe they're going to be on light duty. There's a lot of different examples or situations that would fall within the category of something being a reasonable accommodation that would be applicable for a particular individual. So we just need to make sure that we're aware here about these different standards and keeping in mind what sort of accommodations might be appropriate for an individual who's going to need some sort of reasonable accommodation. And the regulators, when they're trying to do this and putting these thresholds in place and eliminating that component there of having that essential function of the job and who would be a qualified applicant and who would be an eligible employee, they're really trying to say that anyone, a broader pool of individuals, not only in scope of the types of situations which would be eligible for protection, but the broader pool, the qualified employee or the applicant. And with that terminology, we're really talking about an individual, in order to be qualified, would be anyone who could really perform the essential functions, duties, obligations of that particular position without or with the reasonable accommodation, so the extra sitting breaks or the light duty or whatever it is that it would be required in order to fulfill those particular functions. So someone could be qualified potentially for this protection if their inability to perform a certain eligible function or essential function or obligation for the position is just temporary. When temporary meaning just a short period of time, a short duration, or we know or could expect that whatever it is that that particular function is, that it would be able to be performed in the near future. And that's where we're going to start to see some of this overlap too with the ADA. I think the most interesting thing, before I turn this back over to you, Kelly, where we started to see some of these conditions and these concerns from individuals, from states, from others that are involved, is when we first discussed the broad category of situations that could potentially require or make eligible an individual for some accommodation that an employer would have to grant. On that list was abortion. That was one of the related conditions. And that could mean a new physical condition, an existing medical condition, or something that is exacerbated by the actual pregnancy itself. And so we saw from the EEOC comments during the first comment period that when the condition of abortion was part of that definition of what was being included, it created a little bit of questions. People weren't exactly sure of what that meant and how that would apply. So we can anticipate, now that this is live and in effect, that we're going to start to see a ton of questions about the extent to which and how employers are going to have to facilitate these inquiries and these questions that are related to maybe an abortion-related appointment or recovery afterwards. So we really have to be aware of what it is that we're required to do and the current landscape that we're seeing from the courts, from the different states, of how they're going to go about addressing this and how the actual EEOC, what their stance has been on this and what their opinion is. So Kelly, you want to tell us a little bit more about some of the court challenges that we're seeing and the impact that they potentially might have as employers are trying to navigate through this?
Absolutely. So there's two court cases that have come up recently, and they actually came down slightly differently, which is why it's important to note both of them. So there's one case in the Eastern District of Arkansas, which had actually 17 states involved. I'll list them very quickly: Tennessee, Arkansas, Alabama, Florida, Georgia, Idaho, Indiana, Iowa, Kansas, Missouri, Nebraska, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, and West Virginia. So I know I went through this fast. Point is, it's 17 states. It was a lot of them. So this case was there, and it was specifically challenging the abortion leave and the requirement of employers to offer that leave accommodation when it's related to elective abortions. So the federal judge in this case actually dismissed the lawsuit challenging this rule, specifically on the concept of effectively what in the legal world we call standing. So standing means that you have the right to sue. There's some sort of harm. You can actually show that there is harm that has happened or will happen to you. And it means you're the right person to bring the lawsuit, kind of in plain English terms. And obviously they're challenging elective abortions, which is truly an abortion where someone has a choice and makes that choice, and it's not due to the life of the mother being in danger or some sort of other medical condition. So the court dismissed it for effectively 3 reasons. One, specifically saying that it was unlikely to cause significant harm to employers, that it was unlikely to create additional compliance costs, and that there was obviously the open issue that Jen just talked about, that there's an open issue of whether or not the act itself requires employers to accommodate elective abortions. It basically said this isn't the right place to determine the answer to that question. It's still outstanding, or we're still awaiting guidance. So effectively, this was kind of punting the concept, but it's interesting. And again, this is not the end of this by any means, especially when we talk about what happened in the other court case. So the other court case was, right next door, or sort of, I guess, close, not really right next door. Sorry, I was thinking of the wrong state, but it happened in the federal court in Louisiana. And it specifically applies to employers in Louisiana and Mississippi, also related specifically to that accommodation related to elective abortions, because these are states where this is obviously highly contentious related to, providing those services and obtaining those services. So in this case, the judge said the EEOC exceeded its statutory authority to implement the Pregnant Workers Fairness Act, and it came to a different conclusion about the standing issue. It said that the employers had the right to sue in this situation, and the states had the right to sue on behalf of the employers in their states because they actually came with sworn declarations as their evidence showing what it cost them to comply. I haven't seen what that documents are and what that monetary value might be, but that's the big difference between the two cases. In one case, they actually brought evidence showing actual harm, and in another case, they didn't. So likely this is going to obviously continue to be challenged and potentially has its way to work its way up through the court system. Unfortunately, like we know, working its way through the court system takes time and it will be a while before we have a true resolution. But what this second court case means is that employers specifically in Louisiana and Mississippi, so it's limited to those two states, that employers in those states have the option still as to whether or not they want to provide accommodations related to elective abortions specifically. So again, employers have the option, they can do what they wish, they don't have to. Employers that are outside of those states should be a little bit more conservative in their decisions and consider, the current climate of what's happening. So definitely something that employers are going to want to come up with some sort of rules on, and which kind of leads us to our next piece of information that we're going to talk about is what should a plan do? This is a difficult topic and a difficult subject. And when you look at it, it seems like, okay, this is an open shut, really super easy situation to deal with. And then when you start digging into it, it's this layers upon layers. It's like peeling back the layers of an onion, and it just keeps going. So I'll turn it over to Jen to kind of start diving into what an employer should do at this point. What should they do with their health plans?
Yeah, thank you, Kelly. I think this is important. Thank you so much for bringing up those challenges. And I keep going back to the fact that there are these different thresholds here. So what is the first thing that a plan or employer should do? First thing is make sure that they understand the nuances of this statute and what it's going to mean. Become comfortable, familiar, understand not only this particular act, but how it interacts with these different acts. Troubleshoot, ask some questions, and get a background. That is the first and the most important thing to do at this point in time. The other thing is to really have a solid plan, to think through how are they going to do this? What's the process going to be? It's been made very clear to us from the EEOC, from this interpretive guidance, from some of the court cases that we're starting to see, that one of the most important things is acting quickly and being very aware of the fact that unlike other potential ADA types of situations, that this is more of a temporary standard or a temporary station, and that we're changing, modifying the bar here, that the requirement, the essential function piece is suspended. We have to keep that in mind differently than the ADA because our standard is a little bit different. So we need to be having a plan for how HR and how our internal teams are going to be dealing with this. We need to take a look at our benefit plans. Kelly, I want to talk a little bit about the benefits and the things we might want to make sure that we're aware of and we're looking for in our benefit documents to make sure that we're covering or not covering or excluding or otherwise allowing people to really understand the scope of what should be included, and how maybe someone could get help with that.
Yeah, for sure. So when it comes to the common benefits and exclusions we see, it's either it's covered or it's not when it comes to abortion. So when it is covered, in light of all of the things that are happening across the United States in different states and the access for medical care specifically, we have always had options in our template materials to offer coverage for abortions, which is broad reaching. And we were recently, as a result, again, over the last year of all the things that are happening, we put in some additional sample language at the request of many of our clients about potentially covering travel expenses if individuals are in a jurisdiction where it might be illegal or impractical to receive necessary medical care. There's some language options that we've given in our materials to allow employers to cover those expenses well. So that's the coverage piece. It's generally pretty open and shut. Where employers do choose to exclude it, it's generally excluded, but with exceptions. So the common exceptions we see are effectively there's three different buckets. It's exclusions, except where the life of the mother is in danger, if there are medical complications that arise, or if the pregnancy is a result of rape or incest. So those are kind of the two camps. It's either it's covered or it's excluded, except in one of those situations. So relatively kind of cut and dry. Obviously, again, with what has happened over the last year or so, the ability to access has become a bigger issue. It's less about what the plans do or don't cover and more about whether or not somebody can actually get access to it. I know at recent conferences I've been at and spoken on similar topics, I did get asked this question a couple times about, what are we supposed to do if we're in a state where somebody can't get access? And that's where they have the option and why we created that language option of potentially covering the travel for medical care if an employer wants to offer additional benefits to their employees. So it's certainly a challenging time from that perspective. But, there's a couple things that I know we at FIA can do to help. So Jen, you want to talk about that real quickly and then we can close it out?
Yeah. And as we wrap up here, just keep in mind, we always are happy to be a resource, but taking a look at your plan, doing a review of the plan, taking a look at your employer policy. Is this something that you're addressing? Is it in your employer handbook or your employee handbook? Are there certain protocols or procedures that you have in place or documentation that you have historically used for FMLA or ADA purposes? Don't just reuse that and assume that it's going to be applicable for this particular act, because there are changes and there are differences. So at the very least, just make sure that you're addressing any of these concerns as you may start to see them carefully and thoroughly, and applying the actual standards and the rules of this particular act very carefully and very thoroughly. And on behalf of myself and Kelly, thank you so much for tuning in and listening to another episode of our Empowering Plans podcast.